So one of the questions I get asked all the time is, can you describe to me what the process is like of getting a divorce? So I'm going to take a little bit longer. I do a lot of short videos. This is going to be a longer one to kind of explain that process, at least how it works in our office and most of the time here in Southern Utah. So if you come in and you hire us to do a divorce, the first thing we're going to determine is, do we need to file for temporary orders? Now, having said that, the court automatically issues what's called the domestic relations injunction. And this basically puts at a status quo all of the financial matters. So some of the things in this order are, you can't cancel insurance, you can't cancel cell phones, you can't turn off utilities, you can't shut off people's internet service and all of those kind of things. You can't spend money beyond the normal course, right? So if you have $50,000 in your combined checking account, hypothetically, and you move $4,000 or $5,000 in and out every month as you get, money comes in and you pay the bills, you can do that. But you can't go suck $20,000 out of that account. You can't take somebody's name off of that account. So that happens just automatically by the court. If you have kids, very often we look at temporary orders. So what these are is temporary orders is when we ask the judge to say, hey, judge, we need some things in place to help these people get along, to get some stability in place until we can get to a mediation or, heaven forbid, a custody evaluation and a trial. So those are the first things. We determine, are we going to need to do some temporary orders or not? And then, if we don't, then we just do a petition for divorce, which is basically us saying, hey, we want a divorce, our client wants a divorce, and this is what they want it to look like. He or she wants it to look like A, B, C, and D, and we'd like to have the house divided this way and the debt divided this way. We just put all that in there. We'd like custody to look like this. Parent time, we think this is what each other makes, so child support ought to be this. We put all of that kind of stuff in there, and then if there's temporary orders, we'll draft the temporary orders and say, Judge, we'd like these orders temporarily, and write a memo of the law about why that should be granted. And then the next part is we serve it on the other person. Now, typically, service is required to be done by a process server, a company or an individual who specializes, and that's their job and their license to serve papers. A lot of times you use constables, private investigators, and that kind of folks. So they will go out and they will serve the other person. Then that person, if they're in Utah, has 21 days to respond. If they're living in another state, they have 30 days to respond. And then, excuse me. And then once they respond, they'll often respond and say, yeah, you're crazy. I want it to be this way in a divorce. Then once they answer, maybe we deal with the temporary orders, have a court hearing about that. We get something kind of temporarily in place to preserve the peace. Then there's some things that are required under the rules, in particular Rule 26 of the Utah Rules of Discovery in 26.1 called initial disclosures and a financial declaration. Now, the financial declaration, you basically got to say, hey, here's the assets we have, here's the debt we have, here's my income, and here's my expenses, with the supporting documents, tax returns, pay stubs, bank statements, Venmo statements, credit card statements, all of that kind of stuff. We've got to gather that and provide all of that to the other side, and the other side is going to provide all of that back over to us. So now the attorneys and the litigants, they all kind of know what we're playing with. We know the stuff in the pot that we get to divide up. We know what the issues are in custody. The other thing is that initial disclosures, which is typically, hey, here's my evidence and here are my witnesses. Now, honestly, in an effort to save money, a lot of times I'll call opposing counsel and say, hey, do we really need to do these initial disclosures at this point, or can we maybe wait and do that after mediation, because mediation is required in Utah? And sometimes we'll just have an agreement. Look, we'll do the financial declaration, but we'll hold off on initial disclosures, because that costs a lot of money, and it's information. I tell people all the time, I say, look, I know what the other side's witnesses are going to say. They're going to say you're a horrible person, you should never be near kids ever again in your life, and you're the worst spouse that ever was. That's what the other side's witnesses are going to say. What are our witnesses going to say? Well, the other side's that, right? So I don't need to know the specifics if I'm going to settle this case at mediation. But if the other side insists on it, or I just think, look, maybe this will help mediation, we'll go ahead and we'll do that process of making our initial disclosures. Now, one thing that is tough is Utah law requires those things to be done in a very short time period, and quite frankly, most people have a very hard time gathering all of that information within the time frame set out by the rules. So again, I'm reaching out to the opposing counsel saying, hey, can we get a little extension because we've got to find all this stuff and we're having a hard time. And usually, people are professional and civil and courteous, so we grant those kind of extensions quite frequently. Then we prepare for mediation. So in mediation, sometimes we'll have a conversation with the client before and do a lot of prep, sometimes not, but generally we want to know, hey, what might be our opening offer? We might want to know what kind of our walk away. We're not willing to settle for anything less than. The other thing that we really try and do, at least I try and do in my mind as I approach mediation, is Stephen R. Covey said it in 7 Habits of Highly Effective People. He's like, seek first to understand and then to be understood. So my clients are really good. They know their position really well. And I'm going to push back and challenge them on their position so that I can help understand what the other side is going to argue. I want to know their arguments. I want to know what they want and need and desire out of this divorce so that I can help get my client the stuff they really want and give the other side some of the stuff they really want in exchange so we can get it done at mediation. Now, that brings me to mediation. So mediation, it's a great way to resolve things. So generally how mediation works, and it can be virtual or in person. And either way, the same concept applies. So if we're in virtual, we will be in a breakout room, a virtual room, me and my client, and then the other side will be in their breakout room, in their virtual room, and a mediator is going to hop back and forth in between those 2 mediation rooms. If we're physical, it's the same thing. My client and I are in a room, the other side is in a room, and the mediator's going back and forth. Shuttle diplomacy, if you will. Now, there are 2 types of mediators that I have worked with over the years. One is the mediator that comes in and says, well, they've offered this. What do you think? They don't help. They just convey an offer, and then my client and I have to try and figure something out. We typically, it is our practice to hire and use retired judges, very experienced, competent, smart, other family law attorneys in the area. There's a couple other mediators. We use a mediator that has taught mediation professionally at the university level. So we find a mediator that's going to help us, and they're going to help us with a couple of things. Number one, they're going to help us understand the other side's position, right? That seek first to understand and then to be understood. So we can kind of see where the other side's coming from. It helps us craft offers and solutions. They're going to help us sometimes help me if my client's got a position that's just nuts, or maybe not nuts, shouldn't say that, that's just maybe a little too aggressive, that the mediator can help me get my client to back off an extreme position that isn't helping their case and that they might not win that point at trial. Retired judges are really good at helping with that because they can say, look, that argument never worked in my 15, 20, 25, 30 years on the bench as a judge. It's probably still not going to work with judges today. So that's a helpful thing, that getting those mediators, or even an attorney that's been around a long time. Yeah, I've made that argument 4 or 5 times and it's always landed like a lead balloon with the judges. So that's why we use the mediators we use, is they can help us see when we're asking for something or wanting to accomplish something that's just not likely going to happen in court. And then the last thing the mediator can do is they can help us, because see, they're hearing what my side wants and what the other side wants. And they can say, oh, they've got this common ground. And with their experience, they can help maybe brainstorm solutions that neither party has thought of because they've been so entrenched in their position. So mediation, we go back and forth. Most mediations are most are 3, maybe up to 6, 7, 8 hours. I've had a couple that have gone into 12 hours a second day. Those are very, very rare. Most of them, I would say, are 4 to 6 hours. And we settle and we reach an agreement. And some of that time is attorneys quibbling over language, what the sentence should say in the settlement agreement. So most cases settle at mediation. Now, a couple other things about divorce in Utah that you need to remember. Number one is there is a mandatory divorce education class that needs to be taken. We put a notice of it in our standard documents when we prepare a petition. But you've got to take that before a judge is going to sign your case. It's an online class. I think it's taught by Utah State University and online through their extension program. You've got to take that class. That will hold up your divorce if you haven't done those classes. So just remember that. The other thing is if there's child support, we've got to provide some verification and proof of income to the court. typically that's a pay stub. It's confidential. Those are private records. Your information's not getting out, but we've got to provide that to the court. And then we've got to do a child support worksheet. That's another thing. Child support is pretty much non-negotiable in Utah. It's income, time with the kids, put it in a formula, and it gives you numbers, and that's it. Now, we might round, right? If child support comes out to be $502, we're going to maybe round down to 500, so our math is easy going forward. But as a general rule, whatever number comes out of those calculations, that's child support, and it's largely non-negotiable. So other things we deal with in a divorce, spousal support. Spousal support is becoming more and more of a thing. As people have had dual incomes, one makes a lot more money than the other. And so spousal support is based on kind of the positions of the parties and the need of the recipient spouse and the ability of the paying spouse. A lot of times instead of spousal support, we'll give the one that makes more money more of the debt. So that becomes something that we'll do as we work on a divorce. Other things to remember in a divorce is if you've got a life insurance policy, you need to maybe change those beneficiary designation after an order is entered, because changing life insurance beneficiaries would violate that domestic relations injunction I talked about earlier. So just remember that. Other things, you need to maybe do deeds to homes, help people cooperate with refinancing. Another thing to think about after your divorce you need to look at is notifying daycare providers, medical providers, to see if they will be willing to do divorce billing. Generally, the law is going to require that each parent pay half of all out-of-pocket medical, dental, orthodontic, vision expenses. We negotiate a lot of times on the extracurriculars, dance, football, soccer, basketball, ballet, all those kind of stuff. We'll figure out who's going to pay for that, sometimes based on relative incomes. Anyway, that's generally how it works. More than 90% of our cases typically go down that path from start, exchange of information, and a mediation. And I filled in some of the details in this video about kind of how that works and some things to think about. One thing on mediation is it is confidential. If you make an offer at mediation to settle for A, B, C, and D, and they deny that, they can't go to court later and say, well, in mediation, you offered to give me that. Well, they can't. That's inadmissible, because those things are private and confidential to encourage settlement, to try and get people to settle and resolve cases instead of fighting. So they protect offers so they can't be communicated. But the only exception to the confidentiality of mediation is threats of violence, or first time somebody has disclosed that there's been child abuse at some mandatory reporting thing. So if you've got other questions, give us a call. Watch some of our short videos. We go into a lot of topics about some of this stuff. And if you're in southern Utah, really anywhere in Utah with the advent of technology and video conferencing, we'd be glad to help you. Short and one long in the can.
Yeah. I'm sorry, go ahead.
Love it.
I don't know.